will be without prejudice, Your Honor.
With prejudice.
But in this particular instance, it is very difficult to second guess what the Pasig court would have done. The parties to the case intended that the case would be dismissed without prejudice. It was not going to be adjudicated on the merits, and this was what they intended very clearly. And this is how they carried themselves prospectively. But it was difficult to second guess at that point what the court will do. Will it dismiss it with prejudice or not? Is totally anyone's guess at that point.
Let's not second guess the court. Let's read the order of the court. Do you have a copy of the order of the court?
I have a copy of the order, Your Honor.
Yes, please, may we request the Chief Justice to request the party to give the court a copy of the order of the court dismissing the case with prejudice.
Counsel, did you not submit that?
I submitted it, Your Honor, as part of the petition.
It's not?
It's not.
In any case, then you are so ordered to submit a copy within the period that will be granted to you for filing your memorandum.
Thank you, Your Honor. If Your Honor, please, can I just take a glass of water? Thank you, Your Honor.
Go ahead. In the meantime, questions will be asked by Justice Tinga.
Thank you, Your Honor.
Counsel. Well, I have to acknowledge right off that I'm approaching these cases from two perspectives, which are both close to my heart and my mind. That is, emotionally and professionally speaking. On one hand, I played a significant part in crafting the two laws, the original BOT law and the amendatory version. That's why your advocacy of the BOT scheme, particularly the unsolicited proposal approach, strikes a very, shall we say, sympathetic chord on my part. Now, on the other hand, I was the ponente of the Gingoyon decision, so I would like to see to it that that case is not diluted, that ruling. So, proceeding from those premises, I seek to be clarified on certain issues. You are making use of the BOT provision in the BOT laws. That means you would like to be awarded the right to build, operate, and transfer the facility in question. Isn't that right?
Yes, correct.
That's your
Honor.
approach.
That's correct.
So, in a case where there is no facility, no complex called NAIA 3 to speak of in the first place, where the builder, there's no facility to speak of in the first place. And the challenger failed to comply with the requirements of the law, definitely the original proponent would be accorded the right to secure the contract, isn't it? Or even if a facility was built, but the government intends to have the facility built on a place other than on which the failing bidder built its infrastructure. your client would be able to put up the facility on that other site. Isn't that right?
Under the terms of the original proposal of AADC, Your Honor, that would not-
Let us say the government forgets about this facility put up by Fiatco. Instead, it would like the facility to be put up at the Philippine Air Force camp. An entirely new site. On the premise that your position is correct, your client should be allowed to put up the facility in that new site. There will be no problem.
Yes, Your Honor, there will be
No
no
problem.
in that respect, but I would like to point out the realities of obtaining in the
Yes. We are
Okay.
talking about
On that assumption, Your Honor, yes, yes.
hypothetical
I would agree, Your Honor.
situation. But in a case such as this one, where a facility has already been built, ready to be used after some improvement or renovation, what would be the legal basis for a EDC to come in and say, let us take over, because as the original proponent, we have the right, not only to must, but we have a vested right to put up the facility ourselves.
The basis of AADC's right on that basis now, on that hypothetical case, Your Honor, will be simply on the equitable right of pair cargo or Piatco to be paid compensation. Now, because AADC is entitled as a matter of right, as I pointed out earlier, then it will be AADC against whom the principles of unjust enrichment will apply, because it will be AADC that will benefit from the operation and take over of Terminal 3. So this will be the legal basis at which AADC will be compensating Piatco on the basis of that
Yeah.
equitable obligation that arose, Your Honor.
Is that particular situation covered by any specific provision in the law, whether the original one or the Amendatory Act?
No, Your Honor. That particular situation is not covered. What happens when
It is not covered because there is already a facility already built. And AADC would like to operate the facility itself. That is the situation.
Yes, Your Honor.
That's why the BOT law would not apply.
No, Your Honor, because even as there is no specific provision that will cover that situation, there are specific situations that can address that particular situation, Your Honor. In that, for instance, the nullification of the Piatco contract, if I might start from that premise,
Yes.
was done not because it was originally valid. It was not nullified because Piatco could no longer undertake its obligations or defaulted its obligations under a valid contract. But it was nullified as being void ab initio, Your Honor, because it did not comply with the terms.
Yes.
Yeah. So in this particular instance, the provision on what are the rights of Piatco in this particular instance is not covered by the BOT law, because that is covered by another principle or obligation that is based on equity. But insofar as the right of AADC nevertheless to continue with the project, yes, Your Honor, because the nullification of the contract has not rendered the performance of AADC's obligation impossible. It can still and must do it.
But situation is such that the project bidded out has been built already, substantially at least. There is the structure standing,
Yes, Your
ready
Honor.
to be used after some renovation or improvement.
Yes, Your Honor, but notwithstanding the fact that it has already been built substantially, it is the project of the original proponent, of which the original proponent is entitled pursuant to the provisions of the BOT law. And this is what it is entitled to. It is entitled to the project. Now, the project, the reality is that the project already sees a building that has been constructed there.
But the problem is the BOT law speaks of a facility still to be built. It does not cover a situation where the facility has already been built.
Yes, Your Honor, but the BOT law also speaks about when the vested right to the project accrues. The BOT law is also sufficient on that basis. It says that at the time that the construction of the terminal facility was built unlawfully by Piatco, the vested right of AADC was already there. And you could not simply just take out that project of the BOT law coverage because the structure is already there that will be injurious to the statutory right that is granted and was vested on AADC even before the nullification.
Well,
of
in
that
that case, AEDC should have taken steps to protect and preserve its right
That is what we did, Your
on
Honor.
time.
We have AADC, as I understand, Your Honor, has never relented in its effort. In fact, immediately after President Gloria Macapagal Arroyo came into power, Your Honor, the efforts of AADC questioning it and asking government to recognize its rights continued, Your Honor, even after the joint motion to dismiss was signed that was requested by President Estrada. AADC wrote to the President and expressed the very same concerns about why the contract was awarded to Piatco in the manner that it did, notwithstanding the fact that the joint motion was already there. So on that question of whether or not AADC asserted that right and sought efforts to protect that right, AADC did that all along. Up to that time, in fact, I am not too sure whether Your Honor was still in Congress at the time, but AADC actively participated in the deliberations of the House of Representatives and the House of Senate, questioning the legality of the Piatco contracts and the propriety of awarding these contracts to Piatco. So AADC was always at the forefront. And when this honorable court came up with a decision in Agan, and when the decision became final in January 1 of 2004, AADC immediately made representations with the OTC. But it was the OTC that came up with its response only in September on 2006.
All right.
And 1 month after we got the response, which they clearly said that they were not going to recognize AADC's right, we filed this petition for your mandamos, Your Honor.
No, I'm through with that point. I'll go to another, but I have to request you to include that point, address that.
Yes, Your Honor. Thank you.
Now, I remember in Agan, Piatco was disqualified, among others, for not meeting the minimum capitalization investment requirement. I think the required unrestrictable investable net worth of the winning bidder goes as much as
30%.
2.8
3.7, Your Honor.
3.7
Billion.
billion pesos. And I assume that in your advocacy before the court, you are saying that AADC meets the requirement.
That is correct, Your Honor. In fact, as provided for under the implementing rules and regulation, during that period of the in-depth negotiations, during that first 30 days of that in-depth negotiations, AADC must qualify, and in fact, it was pre-qualified by the OTC in that regard, using the very same criteria that was used for the pre-qualification of challengers, Your
So
Honor.
in your memorandum, please stress that, no?
Also, Your Honor.
The subscribed capital stock, the minimum, the paid up, all those things, no? Which after all are very verifiable, no?
Yes, Your Honor.
Okay. Another point. In your position now, are you asking that that Gingoyon be revisited, re-examined, and abandoned if need be?
Your Honor, maybe that will be best addressed by Attorney Bernas, representing Congressman Salakni Baterina, Your Honor, because as I understand, he is going to argue on that matter.
Okay, thank you.
Justice Santiago.
Attorney Asay, since AEDC voluntarily caused the dismissal of the RTC case questioning the PBAC proceedings and did not participate in any other proceedings to nullify the Piatco contracts, should we not consider AEDC as being stopped from asserting any rights which it may have had as original proponent of the project?
No, Your Honor, and I would like to emphasize here that AADC never relented in its effort to question the legality of the Piatco contracts. As I've said earlier, soon after the former president stepped down and was succeeded by President Gloria Macapagal-Arroyo, proceedings and efforts were undertaken by AADC precisely to question this. We, AADC, participated in the Senate investigations, where the Senate committee in particular investigated the legality of the contracts and the award of the contract to Piatco, including the concomitant corruption that surrounded the contracts coming into being. Likewise, in the House of Representatives, Your Honor, we continued with this. We also sat down with representatives of the President's Cabinet and talked to them about the right of AADC in this respect. The only occasion at which AADC did not participate in questioning the legality of the contracts was in the Agan case. And for a very special reason, Your Honor, because at that time, government already took the position that these contracts were illegal. Previously, when we signed the joint motion to dismiss in the Pasig Court, Your Honor, government said that these contracts were legal, that these contracts, the award were perfectly done in accord with law. But in the Agan case, government took a totally opposite position and said that the award was null and void, the contracts were null and void. And at that point, it became unnecessary for AADC to participate anymore because the best entity that was to question the legality of the contract was the agency itself that was tasked to implement it. And that is the only reason why we did not participate in it, Your Honor. But soon after the decision of the Agan case became final, again, we continued efforts to question to in fact enforce the right of AADC to the award of the project, Your Honor.
All right, next question. When the Pair Cargo Consortium was found by the PBAC to have pre-qualified to undertake the NAIA IPT3 project, did AEDC avail of any legal remedy to question the consortium's qualifications?
Yes, Your Honor. Right at the PBAC proceedings, Your Honor, AADC questioned this vigorously. Not only once, but a lot of times, as even the factual citations or enumerations in the Agan case would point out this fact, Your Honor. We did so.
All right, thank you.
Justice Velasco.
Sir Counsel, I want to be clarified the factual setting obtaining at the time of the filing of civil case number 66213 before the RTC Pasig City Court, no? The case was filed on April 16, 1997, is that correct?
Yes, Your Honor.
But prior to that, on December 11, 1996, a notice was issued by DOTC to Pair Cargo Consortium regarding petitioner AEDC's supposed failure to match Pair Cargo Consortium's bid offer. Is that correct?
That is correct, Your Honor.
Okay. And then you're telling us, you told us that there was a joint motion to dismiss filed after the filing of this Pasig case, no? And then, when was the concession agreement signed between DOTC and Pair Cargo?
The first one, Your Honor, was in July of 1997.
Okay, so are you saying that the order of dismissal in the Pasig City case happened prior to the execution of the concession agreement in July 1997? Is that correct?
Upon information and belief, Your Honor, yes. Although, as I was trying to say earlier, the signing of the contract itself, together with the contract itself, and the other agreements that were signed when that contract was signed, was kept top secret, Your Honor. And this was the only reason why AADC agreed to the dismissal of the case in the Pasig court, when the President assured AADC that AADC will be provided with a copy of the concession agreement.
Yeah, but what I want you to clarify is whether the order of dismissal with prejudice issued by the Pasig City Court came before the signing of the concession agreement in July 1997. Is that a fact?
No, Your Honor, it came after.
The
actual dismissal based on the joint motion to dismiss came after. It came in September of 1998, as I remember, Your Honor. In fact, at that time, when the President gave AADC a copy of the concession agreement, he was not really negotiating or talking to AADC in good faith, because at that time, the amended and restated concession agreement was already in the offing and was purported to be signed in November of that same year.
Okay, so you mentioned an amended and restated concession agreement. When was that signed?
This was signed in November of 1998, Your Honor.
And you mentioned a while ago that the order of dismissal with prejudice was signed in September of 1998.
That is correct, Your Honor.
So the order of dismissal with prejudice was issued prior to the execution of the November 26, 1998 amended and restated concession agreement.
That is correct, Your Honor.
Okay. And based on our ruling in Agan versus Piatco, some of the stipulations contained in the ARDA were declared null, were declared void and unconstitutional in that particular ruling?
Yes, Your Honor. Not only ARCA, but also the concession agreement.
Okay. You're familiar with the principle of immutability and unalterability of final judgments?
Yes, Your Honor.
Okay. How is that subject to exceptions?
Well, I think it will also be subject to exception, for instance, because under the doctrine laid down in Salud versus Court of Appeals, that was decided by this honorable court, that, you know, a technical or mechanical reliance on res judicata cannot be invoked in a situation where a societal purpose or value is sought to be achieved by a particular procedure or act, Your Honor. In this particular instance, the avowed purpose of the BOT laws amended 7718 was precisely to protect the original proponent from the corruption of government officials after they would have spent tremendous amounts of money. And so you see here, Your Honor, when you say that res judicata should apply, following the doctrine laid down in Salud versus Court of Appeals, it cannot apply in this particular instance because the purpose precisely of protecting the original proponent is the societal value, as alluded to in this particular instance. And AADC is entitled to that protection. So even assuming for the sake of argument that the rule on preclusion or res judicata applies, there should be no mechanical reliance pursuant to the doctrine, because precisely of that objective purpose, there is a more transcendental, important purpose in upholding the law in this respect.
Can you consider the occurrence of a supervening event as an exception to the rule on immutability and unalterability of final judgments of a court?
A supervening event, Your Honor?
Yes.
I would imagine that based on equitable grounds, a supervening event can be invoked, Your Honor, to question the applicability of the conclusiveness of judgment, Your Honor.
Okay. So when the order of dismissal with prejudice was issued by the Pasig City Court, the parties never considered the stipulations that will be embraced in the amended and restated concession agreement, which was inked on November 26, 1998. Did the parties consider the stipulations of the non-existent amended and restated concession agreement when they filed the case before the RTC Pasig on April 16, 1997?
For sure, Your Honor, AADC did not know. But the government as a party, I doubt very much if they did not know, Your Honor. I think they knew all along that the amended concession agreement was there. And when they, on the basis of their representation to the President, that the concession agreement was going to be given to AADC, which was the precondition at which AADC agreed to dismiss the motion, government representatives at that point in time knew that they were giving something that was already superseded. But AADC did not know about this. So, in fact, the very reason at which AADC agreed to the motion to dismiss was not there, because there was no good faith representation on the part of government in this respect.
Okay. You said that your client, petitioner, is willing and prepared to answer for all the financial obligations pertaining to this project. Is that correct?
That is correct, Your Honor.
And you made mention that there is now a pending claim in the United States by Fraport in the amount of around $425 million. That's the claim of Fraport. You mentioned that.
That is correct, Your Honor. There is
Right.
such a claim made.
And what's the status of the Fraport case right now?
I am not too familiar about the status of the Fraport case because, again, government has taken on the position that all of the proceedings there, including the submission of documents which are of tremendous public interest, are confidential in nature, Your Honor. So I do not know really what has happened there. Maybe perhaps the Solicitor General will be able to enlighten us on what has happened in that case, including the one in ICC, Your Honor.
So, but can we assume that before you filed this petition, you have already analyzed and evaluated the position of the government in that particular arbitration case? Because if ever this contract will be awarded to you, then you will have to consider the payment by your client of whatever amount the arbitration court might adjudge against your client, on the assumption that there will be a finding that the government is liable.
Your Honor, the representation of AADC that is willing and able to pay for the obligations with respect to the payment of compensation to Piatco, including the obligations to finish the entire project and to pay for outstanding obligations to the general contractor, is with respect to that as it relates to the construction or carrying out of its obligation to construct the Terminal 3 on a build, operate, and transfer basis. It does not involve the responsibility and liability of government to whatever entity, including Fraport, for whatever Fraport sees are sins of government or deficiencies or actions of government that led to these liabilities. This is an entirely separate matter over which AADC does not even have any privity but has no obligation to.
But you want the court to grant you the right to operate the Terminal 3, and which will necessitate the execution of an agreement with government regarding the operation of this project. And necessarily, I think the Solicitor General representing the government would see to it that the claim of Fraport will have to be discussed, and some agreement must be entered into on that claim before the government will eventually give you the power, or rather the right to operate the terminal.
No, Your Honor, because the contract alluded to that will be signed by the parties is the draft concession agreement that has already gone through the process of acceptance and approval under the unsolicited mode and under the rules and implementing rules of the BOT law. That contract cannot be amended or changed as to alter substantially the conditions or terms of the original proposal of AADC to include liabilities outside of what is covered in the AADC draft concession agreement. As for instance, the liabilities of government to Fraport, should these liabilities be determined, is not covered in that contract, Your Honor. That's an entirely separate matter.
And your position would be the same regarding the claim of Piatco in the Singapore arbitration proceeding?
The same, Your
In the
Honor.
amount of $515 million?
The same, Your Honor, to the extent that Piatco there is claiming for just compensation based under expropriation of the exercise of eminent domain. What we're saying is that we are willing to pay Piatco pursuant to the decision of this Honorable Court based on quantum meruit, applying the principles of unjust enrichment, that AADC, as it takes over the facility, cannot unjustly enrich itself at the expense of Piatco, Your Honor.
How about the claim of, what's that, Takinaka? Are
This
you
is what we're
willing
saying.
to answer for that?
Yes, Your Honor. We understand that there is an obligation to Takinaka amounting to something like close to $100 million US, because this is a claim from the general contractor with respect to the construction of Terminal 3, and this is part of the cost of the at least $350 million US to put up the facility. AADC is prepared and determined to pay these obligations as well, Your Honor.
How about the claim of Asake Hosan?
That is one and the same claim, Your Honor. As I understand, it totals to something about anywhere between 80 to 100 million, Your Honor.
And have you also considered possible claims by the employees now under the employ of MIA with respect to Terminals 1 and 2? Will that be a part of the responsibilities of your client?
No, Your Honor. And fortunately, this Honorable Court annulled the ARCA and the concession agreement. Otherwise, if they were sustained to be valid, that would be liabilities that government will have to pay. And this is precisely the reason why, among other things, that contract was also nullified, Your Honor.
In the expropriation case before the Pasay City RTC, in case you're awarded the right to operate, what are your possible legal steps that you will undertake with respect to the expropriation case? Will you intervene? Will you be subrogated to the rights of the Philippine government regarding the payment of compensation to Piatco?
We had tried to intervene, Your Honor, in the expropriation case, but our intervention was denied. The purpose of our intervention was precisely only to point out that AADC has an interest in the facility, which the expropriation court must also hear. And the interest of AADC in this respect will necessitate the termination of the expropriation proceedings, because the expropriation proceedings will be inconsistent with the claims of AADC to enforce and uphold the BOT law, Your Honor.
That's all, Mr. Chairman.
Thank you, Your Honor.
There are no more questions from the justices. Thank you, Attorney Asay.
Thank you very much, Your Honors. My pleasure, Your Honor.
The court will now hear Attorney Bernas. You have 15 minutes.
May it please the court, Your Honor, if the court will allow, I would ask for a reservation of 2 minutes for rebuttal after the Solicitor General.
We will see what the Solicitor General will say.
Yes, Your Honor. As by way of preliminary, Your Honors, may I clarify that we do not seek a reopening of Gingoyan, nor is this an appeal of Gingoyan. Our reading of Gingoyan is that the only issue raised there, and it was stated specifically in the decision, was whether it was the rules of court or Republic Act 8974 that would govern the expropriation, assuming that the expropriation would carry out and is valid. None of the parties actually questioned whether expropriation was valid in Gingoyan. And so we rely on the resolution of the court in February of 2006, where the court stated that the interests of the intervenors may be duly litigated in the proceedings below. And so that's why we went back to the trial court to litigate the issue of the validity of expropriation. In my written submission, Your Honor, I pointed out that only issues specifically stated in the courts that are litigated create a preclusive effect. I would shortcut the question on preclusion by stating that the theory of preclusion is based on a single, full, and fair opportunity to litigate. And so if the single, full, and fair opportunity to litigate was not present, then there can be no issue preclusion. And again, Your Honor, we rely on the court's resolution of February stating that our interests could be litigated. And now, in stating the importance of deciding Agan, Your Honor said that what was at stake was the country's premier airport, the huge investment, the BOT laws, and the other investment laws in the country. Thus, those considerations still hold today. In relation to the cases today, however, there are specific questions that demand a full discussion and resolution. At the heart of these cases are not simple questions on property or expropriation, nor is it simply about whether AEDC has property rights or vested rights. We all know that the structure is there, and that creates complications. We also know that the contract was voided after substantial performance of a contractor was performed. And so this is not a simple question. The contextual framework for today, Your Honor, is a series of legal events which culminated in Agan. It is the aftermath of an annulment of a contract that triggered the decision to expropriate and triggered the claim of AEDC to resurrect. And so, Your Honors, it is the effects of the aftermath of a voided government contract that is at the heart of today's controversy. Now, there have been discussions on this question based on civil law, based on the BOT law, and based on general principles. However, Your Honor, there is a specific body of literature about voided government contracts that must be addressed, and I think are more appropriately applicable to the issues. It is not just simply civil law concepts or BOT concepts. I propose, therefore, Your Honors, that both these cases are ultimately about the following issues. First, what rights and obligations remain after a contract is voided? Second, whether any payment is due to any party who has performed under a contract that was voided. Third, if any payment is due, what kind of payment and what standard? Next, whether the political decision taken by the executive department to expropriate as a means to pay Piatco is proper or even lawful. Whether the nullification of the Piatco contracts or the expropriation already initiated removes the Terminal 3 project from the scope of the BOT law. And as a matter of practical concern, I would also suggest that Your Honors might be interested in inquiring about whether how the expropriations will affect the ICSID and the ICC arbitrations. Justice Gutierrez asks about what benefits the government might gain, and Justice Puno also asked questions along the same line I could also answer those questions from my viewpoint if Your Honors would like, although it's not the main portion of my presentation. Now, because the government elected to expropriate, and of course it is my view that the expropriation is inappropriate, it does not establish the correct legal relationships among the parties affected. And so unanticipated issues, such as the ones we have today, have arisen, and the resolution of which are now held hostage by really, Your Honors, an unconvincing status of the expropriation. If my client is right, for example, Your Honor, that the expropriation is inappropriate, then Piatco would only be able to seek, at best, quantum meruit payment. Now, that would be in the vicinity of about $275 million or so. And I take this from the statements of the government about the kinds of evidence that has been presented that relate directly to construction costs. If expropriation is available, then Piatco is entitled to more than quantum meruit. They are entitled to just compensation. And when I use the term just compensation, I refer to the specific nomenclature of the Constitution on what it means. Piatco would be entitled to payment under Republic Act 8974, not only of construction costs at current value or current market costs, but also to profit, overhead, and other attendant costs at a company that accompanies the acquisition and installation. And I think this is important, Your Honor, because during AGAN, I remember that during the oral arguments, certain soft costs were discussed, which of course should not be compensable. But under just compensation, they may be. As Your Honors know, actually more from newspapers rather than from court records, Piatco has launched a suit at the ICC where it seeks a ruling that it is entitled to retain and operate Terminal 3. Now that, Your Honor, is inconsistent with the expropriation. And so Your Honors might be interested in how that affects all of this. And in the alternative, Piatco seeks recovery in the concept of just compensation under eminent domain. May I point out that under the Piatco contracts, liquidated damages are specified if the contract is annulled or declared illegal. And these liquidated damages would include the unpaid loans of Piatco, the equity of the investors, and a certain return stipulated at 15%. Now, in Menchavez versus Teves, under the ponentia of the Chief Justice, the court explained that nothing arises out of a void contract. Perhaps maybe under quasi-contract something may arise, but under the contract, nothing should be, no rights should arise. I'm afraid, Your Honors, that if expropriation is carried out, then the government will actually be paying those liquidated damages. And may I also point out, Your Honors, that there is a pending case at the ICSID where Fraport, an investor in Piatco, also claims that its investment has been expropriated and claims more or less about another $500 million. In the arbitrations, both at the ICSID and the ICC, the law that governs is Philippine law.